Remedies in contract law. An individual may receive remedies under contract law as a response to a breach of contract where the innocent party seeks to enforce their rights or obtain compensation. The types of remedies an individual could receive are damages, equitable remedies, and consumer remedies. Damages. Damages are a common law remedy designed to compensate the claimant for loss suffered as a result of a breach of contract. The basis for a claim in damages are that there must be a valid contract, a breach of that contract, and loss caused by the breach, as shown in the case of Robinson v. Harmon. Compensatory damages are intended to put the claimant in the position they would have been in had the contract been properly performed, as shown in the case of Robinson v. Harmon. Causation must be established as a direct link between the breach of contract and the loss suffered by the claimant. In contract law, causation is determined using the but-for test, as shown in the case of Barnett v. Chelsea and Kensington Hospital Management Committee. Remoteness of damage. Remoteness of damage means that only losses that are not too remote and arise naturally from the breach can be recovered, as shown in the case of Hadley v. Baxendale. This is required to receive damages as the loss must not be too remote and must have been within the reasonable foreseeability of the parties at the time the contract was made. Foreseeability of losses means that the type of loss must have been reasonably foreseeable to both parties when the contract was formed, as shown in the case of the Heron II. This is required to receive damages as only losses that were reasonably foreseeable when the contract was made are recoverable. Special situations. The special situations where an individual can receive damages include distress and loss of amenity. In cases of distress and inconvenience, an individual will receive damages where the contract was intended to provide pleasure or freedom from distress, as shown in the case of Jarvis v. Swan Tours. In cases of loss of amenity, an individual will receive damages where the purpose of the contract has been substantially deprived, as shown in the case of Ruxley Electronics and Construction Limited v. Forsyth. Mitigation and liquidation. The claimant must mitigate their loss, which means that they must take reasonable steps to reduce the loss that comes from the breach of contract, as shown in the case of British Westinghouse Electric and Manufacturing Co. Limited v. Underground Electric Railways Co. of London Limited. Liquidated damage clauses are a contractual term where the parties agree in advance a payable sum if a breach occurs, and they are enforceable if the amount protects a legitimate interest and is not out of proportion to the interest of the contract, as shown in the case of Cavendish Square Holding BV v. Macdessie. The enforceability of liquidated damage clauses depends on whether the clause represents a genuine risk of loss rather than a penalty, as shown in the case of Cavendish Square Holding BV v. Macdessie. Equitable remedies. Equitable remedies are discretionary remedies awarded by the courts where damages are inadequate to achieve justice. Specific performance is a court order requiring a party to carry out their contractual obligations, as shown in the case of Bezic v. Bezic. Injunctions are court orders requiring a party either to refrain from doing a specific act or to carry out a particular act, as shown in the case of Lumley v. Wagner. However, these equitable remedies may not be granted if the claimant has not acted equally, if there has been delay, or if supervision by the court would be impractical. Consumer remedies. Consumer remedies are statutory rights available to consumers where goods, services, or digital content fail to meet the required legal standards. They are governed by the Consumer Rights Act 2015, which sets out the standards that goods and services must meet and the remedies available where those standards are breached. The right to reject, or partially reject a good, means that a consumer can refuse goods that are not of satisfactory quality, fit for purpose, or as described and obtain a refund, as shown in the case of Rogers v. Parish Limited. There is a time limit, which is 30 days from delivery. This is because the short-term right to reject must be exercised within a clear statutory period to ensure certainty for both parties. This right must be exercised by clearly informing the trader of the decision to reject and making the goods available for return or collection. This is shown in the case of Clegg v. Anderson. Reduction in price is a remedy where the consumer may keep the goods and claim an appropriate reduction where repair or replacement is impossible or unsuccessful, as shown in the case of Bernstein v. Pamsun Motors Limited. Having work redone is a remedy where a consumer can require the trader to repeat a service to the required standard at no extra cost and within a reasonable time, as shown in the case of Honig v. Isaacs. Thank you for watching this video on remedies in contract law. I'll see you in the next one.